Welcome, everyone. This is Maria Malone. I just wanted to let you know we're just going to wait another minute or so here to allow the rest of our participants to join us. So please just sit tight and we will get started very shortly. All right, welcome everyone. We're going to get started. Again, my name is Maria Malone. I'm with Caber Hill Advisors, and today we're going to touch on legal, financial, and valuation insights focused in the med spa industry. And, our commentary will be around establishing, growing, and acquiring in the space. I'm going to turn it over now to Andrew Christian, just to give him, to allow himself to give him a brief introduction. Then we'll kick it over to Ed, and then we'll get started with our content.
Thanks, Maria. Appreciate it. Andrew Christian here with CLA, principal in our transaction advisor group focused on healthcare M&A. Lead a group of about 15 folks across the nation who focus solely on healthcare M&A transactions, and looking forward to speaking with everyone today. Ed?
Good afternoon, everyone. I am Edward Cyran. I'm a partner at Fox Rothschild, LLP, and I am a healthcare lawyer. So I spend all day, every day, advising healthcare providers, including med spas and their owners, on everything from establishing the med spa to selling it. So I'm going to start us off now in the presentation with the first section. Maria, go ahead and advance the slide. And we are going to talk about things to consider when forming and growing your med spa from a legal perspective, and obviously, if you're acquiring, then what you're looking out for. And if you're going to sell, what you may need to do to prepare yourself legally from a compliance perspective to be attractive to buyers. So in the med spa industry, the number one legal issue, not the only, but the number one legal issue revolves around what's called the prohibition on the corporate practice of medicine, which is, in our words as lawyers, we call it a legal doctrine. And that's because it's not just a simple law. It isn't something in any state that just says a non-physician can't own a medical practice. It isn't as simple as that. It takes the form of various laws and regulations, and it does vary widely by state. It can be in the form of professional corporation and PLC laws, which you've probably heard of, meaning that you and I can't own any interests, any shares, any units in an LLC that is a professional corporation or PLC in that state. But the truth is, medical practices in many states don't have to be formed as a PC or a PLC by that simple law. It's when you combine that law with others that law ends up really funneling everyone into that corporate type. So the other types of laws and regulations that sort of comprise this corporate practice of medicine doctrine You have your Medical Practice Act and related regulations for licensure of physicians in the state. You have anti-fee splitting laws and regulations and anti-kickback laws and regulations. Fee splitting is different than kickbacks. Fee splitting means, and this is common, this is found in New York. Another version of it is found in North Carolina and some other states where there's a specific regulation or law, whether it's licensure related to the physician or not, but it applies to the physician, and it specifically says that that healthcare professional can't share the revenue that they receive for the services they provide with someone who is not a licensed healthcare professional of the same type. So that would include a management company or a layperson, etc. Kickback is specifically that a healthcare professional can't pay someone else to generate business for them or receive a kickback from someone else for engaging in the practice of medicine for them or their business. And then the last thing is case law. And this is actually where it all started, long before any of these laws or regulations even existed in any state in the country. In the early 1900s, there were cases about different types of healthcare professionals who were employed by department stores or were employed by people who just didn't have the same license. And there were problems. There were patient complaints about, quality of care, et cetera. And that led to courts deciding from a public policy perspective that it just didn't work. So this is really a totality of the circumstances test that we always do as lawyers for our clients, where we're analyzing the state's laws and regulations and applying that to what they want to do with their structure. All right, next slide, Marie. In the MedSpa space specifically, there's a whole layer of complexity that's added to this challenge, because the question becomes, how much of this is a medical practice? How much of it is some sort of other practice? And what does that mean? Because again, it's not as simple as you look at one statute and you have an answer. So which services are being provided at this med spa? Which of them are medical? Which of them must be performed by a physician or could actually be performed by a nurse practitioner or an advanced practice nurse, depending on the state we're talking about, a physician assistant, both of whom either collaborating with or supervised by a physician. Which of these can actually be performed by a registered nurse? How about a medical assistant under the supervision of a physician? And then what about others, like a licensed practical nurse or an esthetician? Both of those are commonly licensed in the states. Can they do any of these services, and to what extent do they need to be supervised? All of that goes into the particular structural analysis. And then even with all of that, really from a state-by-state level, there's sometimes clear guidance on certain things. There's sometimes unclear guidance. Lasers and laser hair removal is a hot one. Cool sculpting is another one. Botox is always common in med spas and varies a lot in how it can be administered. Semaglutide, which has been in the news lately. Weight loss drugs are part of med spa services in some cases, and how they're handled, what specifically must be done from a prescription dispensing standpoint, can vary by state law. AmSpa, which I'm sure many of you are familiar with, the American Medical Spa Association, does publish a 50-state survey for their members, and I have a copy of that. I can tell you that in my experience, it is often not correct on a number of different issues, not just because their way of approaching it may not always get the correct answer or advise well with respect to a risk perspective, but because these laws and regulations, especially the regulations, change from time to time in these states as medical boards and cosmetic boards, we're talking about estheticians, nursing boards, we're talking about nurse practitioners, registered nurses, these things can change. The position of those boards can change. And when that happens, what services require what kind of supervision, et cetera, also change. All right, next slide, Maria. So let's talk about the two different scenarios that generally can come up here with this legal issue, right? So I mentioned that a lot of states in the country prohibit the court practice of medicine. Not all of them do. Ohio is an example of one that does not generally. So in the states where we call them non-CPOM states, non-CPOM states, where you and I can own the actual MedSpa entity that provides the services and bills the patient, the general structure is that there's one entity, it's owned by a non-practitioner, and the practitioners, who, again, may still need to be involved in various different ways, depending on the services being provided and what that state requires. Could be a physician, nurse practitioner, PA, esthetician. They're all employed by the MedSpa entity. It's a very simple business structure, whether you're talking about establishing it, growing it, or acquiring it. It's very simple. It's what everyone wishes that it could be in every state. But it's important to remember that even in those states, if you own the entity, you still can't influence the practice of a licensed profession, whether it's medicine, nursing, or aesthetics. You can't, and what does that mean, right? People ask me that all the time. Well, it can mean a number of different things. Some of it is spelled out in regulations for that license. Some of it is not. But the idea is that you can't influence that practitioner in how they perform a procedure or whether they perform a procedure on a patient by any means, right? Whether you're going to threaten termination, you're going to threaten to change their compensation. A common one that comes up too in some states, they actually prohibit non-licensees from controlling the fees that can be charged to the patients, and only the practitioner can determine that. So there are a number of landmines to be careful of, even when you can actually own the entity outright. Next slide, Marie. In the states where you can own it outright, the general structure gets complicated, and it gets complicated very quickly. You have to have that practice entity, the PC, the PLC, professional corporation, PLC, that's owned by the physician, medical director, and then you have to own a management company, that's going to provide some services to this PC so that you can charge a management fee and hopefully get the profit out of that business. So indirectly, you kind of own the practice, but you don't legally. And of course, just like in the non-CPOM state, as a management company or its owner, you can't influence the practice of medicine or other licensed professions by those providers. What happens in this structure is that the management company owns the assets of the business, the critical assets that are really necessary to run it. What does that mean? Well, they're the tenant of the space, party to that lease with the landlord. They own the equipment and lease it to the practice for them to be able to use that equipment. Think of a laser, for example. And so they would also have the equipment lease responsibilities to pay for that asset. They own all of the computers, the main office-based tangible assets of that practice. And they will pay for the fit out of the space, right? And then they also employ the non-clinical staff, those who aren't licensed, who can be employed by any business, right? So think front desk, think medical assistants if they're not certified or licensed in the state, and any other office managers, right? Back office staff. They get to employ all those folks, and they effectively provide the services related to those employees to the PC. And that's all combined with other higher level intangible management services like accounting and bookkeeping, et cetera, strategic services, marketing, and then in exchange, the management company gets paid a fee. Next slide, Maria. So in a number of states that do have this CPOM doctrine, they either may not enforce it, or they may not have a problem, and I say that very generally speaking, not to get into the weeds with it, with the type of fee, right? It might be okay in that state to have a profit suite management fee, which allows you to be the indirect owner of the business. You are scraping off the top the entire profit, and nothing's left over in the entity at the end of the year. So nothing would be distributed out to the physicians, and they also don't have any taxes to pay because if it's done correctly, there's zero net income, right? Because the management fee is just an expense of the practice that gets deducted. But in other states where we have fee splitting laws that I was talking about and the kickback laws, it becomes a real challenge because now you can't just say that your management fee equals the profit of the business for that period. And you actually can't even say that the management fee is a percentage of the income or percentage of the revenue. You have to look for a different type of formula. And so we have to consider those states' laws and how we design that formula. And this happens a lot, but if the med spa is not operating under a compliant formula in that state, it is a significant risk. It doesn't mean that it is definitely a risk, but it can be a significant one. And what I mean by that is, what the resulting fee was during the years that it operated, and you're looking back at that in due diligence, for example, that could be a source of liability if that fee exceeds the fair market value of the services provided by the management company. So without getting too detailed, that can become problematic. So in any event, that's a risk standpoint, but if it were to be enforced, it really becomes a question of, to what extent is that fee a control mechanism over the physician owner of the practice, right? And so it's not as simple, well, that fee, profit sweep fees are not permitted and therefore it's a violation. In some states, maybe that's the case, but oftentimes when we're looking at whether or not this particular med spa was structured in a way that is non-compliant or violated the law, the corporate practice of medicine doctrine and all its facets, we're really looking at that same totality of circumstances analysis. And so with that, I'm going to jump down to this next part about control over, go back, Maria, sorry, about control over the PC. Because everyone in this scenario, my clients always want to know, well, how can I change the physician if he or she's bothering me, or I'm not getting along with them, or they want to leave, or they want too much money? I have to be able to control them. It's my business. Well, again, legally speaking, the practice is not your business. In this form, the management company is your business. But absolutely, there is that concern. We call it sometimes succession. We call it sometimes cooperation, depending on the scenario. Succession could also include if the physician died. How do you find another physician immediately so you don't have a gap in coverage and being able to operate, right? So documents can be created and have, it's different, med spas in different states. They might engage a healthcare lawyer. They might engage a general practitioner. Depending on the sophistication of the lawyer, they may have created some sort of documents that they think give the management company and its owners control over that physician, medical director, or that nurse practitioner, whoever it may be. They could sometimes be in the form of a restriction and option agreement, an employment agreement. And there are other things you may want to consider trying to impose control over the practice with, or things that you want to control, like the intellectual property of that practice, and licensing over the name, for example, or having a security interest in other assets of the practice that may exist if there are any, such as the patient records, to try to give yourself some leverage. But in all of these instances, right, you never want to have to enforce these contracts. And that's the biggest point. And that's why it's very important that a knowledgeable healthcare lawyer is designing these documents, whether when it's time to establish the med spa, when it's growing, or when it's going to be acquired, and we're talking about what the seller has in place. We want to be really careful because every state's going to vary a bit. Every CPOM state is going to vary a bit with what kind of documents they're going to really see risk with, right? Risk that you're trying to control that physician. And if you put those documents in place and you don't try to enforce them, that's an okay position. But it would be better, right, if you didn't have those documents in place at all. And you obviously then have nothing to enforce if you're going to get investigated, depending on the state, right? So we have to analyze these things and say, is it really the right thing to put these kinds of agreements in place? You probably are familiar with some of these. And sometimes it is, sometimes it's not. But certainly there are other ways that you can try to address these issues, and I advise clients on that. All right, go ahead, Maria, to the next state. All right. So just from a transactional perspective, a few tips that I wanted to bring up. I mentioned due diligence. Is this structure correct under the state's law? And what's the liability history for this practice? So what's liability in this context? Well, it could mean the structure, but it could also mean other types of liability with respect to malpractice and insurance. So we often ask for insurance loss runs for the last 5 years. Have there been disgruntled employees? Have there been settlements with employees? Department of Labor investigations at all? Those kinds of things can lead to potential risk in this space more than other businesses because you're drawing the spotlight to this enterprise, right? You're to this practice and the management company. If you were doing that from a governmental perspective, anything's fair game. They can ask about your structure. They can ask for your organizational documents, etc. So liability history and the future potential liability matters in that regard. Whether there's been continuity with professional staff is obviously important, like we were talking about from a cooperation perspective, and whether or not they're going to last with you as the new owner. And then in the purchase agreement itself, you got to do an asset deal for the management company that currently owns the assets of the MedSpa that you're targeting, right? But what do you want to do with the practice, right? Do you want to keep the same medical director? If you do, you don't have to do the deal. But if you're going to use a new medical director, or you're trying to avoid liability that existed with this practice before, the best thing to do is an asset deal so that you have your new professional corporation owned by your new medical director by the assets of that old one. That old one disappears and dissolves eventually. And with it goes its malpractice claims, hopefully. And certainly that's a way to limit as much as you can. You would take the lease assignment, make sure that you're on top of that. The landlords can be a challenge sometimes, depending on the scenario, the building, etc. And then restricted covenants are always important. Certainly, you want a non-solicitation covenant in place for employees and clients of the practice, but also, what kind of non-compete do you want to impose upon these sellers to ensure that you protect the territory? All right, with that, we're going to take questions at the end. We're happy to answer them at that time, and I'll turn it over to Andrew to talk about financial considerations.
Yep. Thanks, Ed. Appreciate it here. We can, so we're gonna start here a little bit more broadly, and then we're gonna narrow in on some areas that we see successful practices and groups do. Maria, go ahead and advance the slide here, please. Okay, so we're gonna go back to kind of basic financial fundamentals here for a moment. Sometimes it's easy to get lost in the day-to-day. So here are some kind of helpful tips and ideas here to unlock your practice's potential. We're going to highlight a couple of these or a few of these, not all of them, starting with prioritizing financial goals. It's important fundamentally to not let goal setting be a lost art, and to set clear financial goals and prioritizing these goals and help align resources to effectively achieve those goals. Some of those goals may be as simple as, I want to grow my practice from $1 million to $2 million in revenue, or add an additional location, or bring on a financial partner to help grow. But I think it's important to define and well establish these goals with the end in mind, and then build that roadmap throughout. Making informed decisions. Making informed decisions with accurate and relevant information help you make sure that you are accountable to those decisions. You want to make sure that you model out some of those decisions, and financial modeling doesn't have to be an extensive exercise. For small businesses, it's really important to strike a balance between the financial nature of the business and the operational nature of the business with limited resources. So an example of how you would model out a scenario would be as if you are considering offering a discount on a service. the natural question would be is what additional volume do you expect to drive with that discount? And that modeling exercise can really help you determine whether you think that that's a reasonable exercise to continue through. And this also helps you professionalize the decision-making part of the business. It's important to measure the impact of those decisions. A lot of times we see groups struggling to measure how those decisions that they've implemented really pay off. And an example of this is a marketing program. You're implementing a new marketing program, and we see a lot of small businesses implement a program but not necessarily have the means to measure that program. We really want to distinguish a successful marketing campaign from a non-successful marketing campaign, because that ultimately can be considered in the valuation. Manage and allocate resources. So effective resource management and allocation is important because we want to align those resources with those financial goals that are going back to that first point there in really goal setting. This can include what functions may be outsourced versus internal hires. It's very common for small businesses to outsource certain functions of their business, such as bookkeeping or payroll. Others may implement systems and technologies to augment when hiring may not be an option or fit within your financial goals. Continuous identification of areas of improvement. These are things like implementing new systems, accounting systems. If you're scaling to a multi-location platform, is QuickBooks the right platform for you, or is there something more robust that can integrate well across different platforms, your medical records platforms, etc.? Aside from implementing new systems, just monitoring performance metrics, understanding your production mix, your revenue by appointment, some productive analytics, new patient consultations, rebooking rates. These are just some examples of ways that you can easily measure your business with the data that you're already accumulating. And another point to that is you don't have to measure this all yourself. You can tap into your financial advisors to assist with that, provided that you can provide the information. Driving accountability, a very important point here, that you're tracking performance, you're ensuring that the financial goals are met. Oftentimes buyers will come in and implement new processes. And speaking from a seller's perspective, if your team's not accustomed to the accountability aspect, this could be a disruption under a new ownership and a new partnership when these processes are implemented. So really making sure that we have clear accountability amongst the team members. Folks understand their roles and responsibilities. That always goes a long way. We're going to touch real quick on brand awareness here. Recognizing that your brand has value is very important. Well-recognized brands can lead to an increase in revenue and customer loyalty, and there's a number of ways you can do that. We're not going to go through all of them. Some of them may include leveraging social media, optimizing your website, implementing marketing campaigns, and alike. Diversifying your revenue stream, very important. Understanding your revenue mix is important. That helps mitigate concentration risks. It also helps ensure the stability of the revenue of the complete organization, especially in a regulatory environment that is subject to change. Understanding when funding is needed, another important step that probably doesn't get thought of enough, is if your goal is to scale and to continue to grow at a location, that would require resources. Can your existing cash flow support that expansion, that growth? Do you seek debt as an option, or equity, or a combination of both? just really getting back to understanding the financial goals and then really building that roadmap. And then finally, securing the exit strategy. Defining an exit strategy helps you put those processes in place, the things that we had discussed previously, and ensures that you're maximizing the value upon exit. Maria, if we can advance the next slide here. So we kind of talked about financial fundamentals here. Now we're going to move into more financial statement basics, understanding the financials being the first one. So it's really important to understand your company's financial health and performance. To no fault of their own, it's very common for small businesses to measure their financial performance by how much cash is in the bank. I would encourage those business owners to dig in and really understand the drivers of their business. That not only helps really make decisions, as we had touched on before, but it also elevates the financial sophistication of the business and ultimately is favorable to buyers when that time comes. Now, diving into the different statements that are important here, the balance sheet is really a snapshot in time. So that really helps assess the company's financial position and stability. We typically see less emphasis on the balance sheet, particularly with smaller practices. Oftentimes, things like inventory, accrued expenses, prepaid expenses, deferred revenue are not recorded on the balance sheet. And this isn't uncommon. But these are opportunities to really display completeness in your financials and demonstrate taking it a step further in the professionalization of your business. This also comes into play when you are in a transaction and you are calculating the working capital needs of the business. So when you're in a due diligence process and these things aren't recorded on the balance sheet, someone will have to calculate that. So that's just another step that if you plan accordingly and you're able to really focus on the completeness of the financials, that just helps kind of keep things smooth throughout the process here. And these aren't hard things to do. So if we're talking about things like inventory, that's monthly inventory counts. And oftentimes those are already being done. It's just not being booked to the financials. You can ask your accountant to accrue for payroll annually or monitor prepaid expenses so that if you are paying for insurance, you're spreading that expense over the year, just as an example. Moving to the income statement here, this shows the company's revenue and expenses. And this really helps understand the operational performance and profitability of the business. Now, where we see some inconsistencies here is when where on the P&L things are booked. We often see inconsistencies when new vendors are brought on, or there's no measure of gross margin or true gross margin, which is really the separation of direct and indirect expenses. Things that a buyer will likely key on in a diligence process. If you have a multi-location entity, ensuring that the revenues and expenses are allocated to the appropriate locations is always something to focus on, because you really want to be able to evaluate the profitability on a standalone basis. So EBITDA. This really is really a foundation for how businesses are valued, the enterprise value of the business. And what EBITDA calculates is really the operating performance, excluding any of the non-operational activities. So I think one common misconception here is that buyers or prospective buyers really only look at EBITDA as a point in time, but I would challenge that, because typically diligence processes are looking at multiple periods. So I think what I've seen is that buyers are interested in looking at EBITDA as over a period of time, and oftentimes that's could be a 2 or 3 year period. So we really want to make sure that we're thinking about the sustainability of our EBITDA, not just kind of at the end of the year, but really over a elongated period of time. And then I'm going to touch on cash to accrual here quick. This is something that comes up a lot in diligence processes, and oftentimes tends to be a little bit of a sticking point or a misunderstanding on how that translates to normalized EBITDA. So very simply put, cash accounting is revenues and expenses as they occur. And really the simple way of thinking about that is you have revenue that comes into your bank. You have an expense that leaves the bank account. That's really just a mirror image into your financials. When you get to something more of an accrual accounting, that's really matching the revenues and the expenses in the periods that really they belong in. So for example, if you're taking an annual membership and that happens at the first of the year, you're going to have that increase in cash in the beginning of the year. But that revenue is really supposed to cover the entire year. So that's kind of one example of why cash to accrual conversions can really swing EBITDA depending on the type of business. Maria, we can advance the slide here, please. All right, so now that we talked about financial fundamentals and then we talked about the financial statements, let's talk a little bit about pre-deal readiness. Going back to very simple things to consider here, which is understanding your financials in its current state and being prepared to speak to them is very important. Leading up to a diligence process, identifying in advance non-operational activity. These things can include add backs, one-time non-recurring activities, capital expenses that may have been expensed through the business. So example would be if you replaced an HVAC system and you paid for it on your credit card and it somehow made it onto the P&L. Just going through and itemizing things that are really non-operational in nature. Some other things would be startup cost if you're opening a new location and there's some cost or expense that's incurred. You revamp your website, things like that. So really just getting a tally of all of those expenses down to the transaction level really helps identify and get to a more finer, predictable EBITDA number. In advance, organizing information that support the financials. So when you get into a due diligence process, there's a lot of supplemental information that's requested through that. Oftentimes it's payroll, employee rosters, bonus programs, revenue reports, lease agreements. Gathering all that information in advance is always helpful because it will be asked during the diligence process. And then finally, consulting qualified advisors. So your attorney who focuses on M&A, bankers and brokers who align with your financial goals and can really advocate for your business. And then accountants and consultants who can speak to your financials and help advise or identify where there might be gaps in valuation or areas where you can improve your financial position. Maria, we can advance the slide, please. So now we're moving into due diligence. So what is due diligence? Really, due diligence is a process is a verification process to get comfort around the economics of the business. And a lot of times it can be a lengthy and in-depth process. So here are a few things that a few pointers through the diligence process that may be helpful and common areas that we typically see when we're going through these processes. So I'm going to start with mindset matters. I think sometimes that's a little bit of a lost thought here. Just having a positive approach and a positive attitude to the process is always very helpful. And that just helps navigate challenges more effectively. Inevitably, in these type of processes, there's always some bumps in the road. So just having an open mindset and a positive mindset through that process gives confidence to the buyers on who they're partnering with. So if you have a positive attitude and a willingness to work through things, that is positive to buyers when and partners who will come alongside you to help you in that growth journey. Understanding the diligence process. So preparation is really key in this process. Understanding what is being looked at, how all the pieces fit, as I mentioned before, payroll, bonus programs, all of those things, revenue reports, they're going to be going into the diligence process. And to the extent that you can familiarize yourself with that process is always very helpful. Setting realistic expectations for the process, I think, is always something that is quickly bypassed. I often see overly aggressive timelines. Generally, that leads to some friction if timelines are slipping. So just really making sure that the timelines are realistic, they're agreeable, and they work for both buyer and seller. We talked a little bit about understanding buyer needs. Probably don't need to rehash that. Managing to a timeline. We talked about setting a realistic timeline, but you really do need to set a timeline and making sure that you have clear, well-defined milestones established. That's very important. So cadence calls, things that are set in advance. With preset agendas. Many times meetings do not have agendas, and that can often lead to an inefficient use of time. We always want to make sure that agendas are provided in advance so that you as the seller or buyer know what the context of the meeting is, what's going to be covered, and time to be prepared for that. And then just staying well organized, working off of checklists, delegating to team members that may be aware of what is going on in the background is really important to help alleviate that compression in that process. So Maria, I will turn it over to you here to take us home.
Thanks, Andrew. So I'm going to address currently what's kind of going on in the market and also how some of that relates to thinking about valuation and potential deal structures. And so first, I just wanted to set the stage with the size of the market that we're looking at. So as of 2023, the MedSpa or medical aesthetics space was about $23 billion. And the projections are that will grow, 13% per year, which is a pretty aggressive growth. And we have long seen interest from private equity, family offices, et cetera, in healthcare businesses in general. And, just for a point of comparison, in the dental industry, where we've seen consolidation happening for, 20, 25 years now, that is an industry that is about $190 billion, but a much lower growth rate. So we typically see a 2 to 3% growth rate for dental. And, looking at dental, without having like real specific numbers here, I would say that industry is, somewhat 50 to 60% consolidated. But, we are in the last several years in particular, we've seen definitely a focus in the med spa space. I think originally, in this area of healthcare, investors were primarily focused on dermatology. I think investors felt that was a less risky investment because there was more insurance payment driving revenue. And, I think there's been a shift now to understand, especially with the projected growth in medical aesthetics, that this can be a very attractive investment opportunity. So, we are in the very early stages of consolidation. There are a number of private equity backed groups that are actively looking to grow. I would say primarily through acquisition. Um, we've now, thinking about the difference between a healthcare business that has a strong insurance component compared to what we're seeing in this space, which is primarily, fee for service. People are paying out of pocket for the services. We consider that to have low reimbursement risk because there isn't a chance that an insurance company is going to decide that they're going to lower how much they're going to reimburse for particular types of services. Um, also in this space, what I think is really interesting is the recurring revenue stream, which is generally generated by membership plans or membership programs where you really your relationship with your client is much stickier. There's more likelihood that they're going to come in on a regular basis and not only do that, but potentially increase the services that they're receiving based on new offerings that you might have or based on new needs that they have. And so that's at least for me, I think that's a very interesting aspect of this space in particular. And I've seen some very interesting and or compelling data around implementing those programs and how that translates to clients really increasing their spend when they are a part of those programs. And then, as I said, we are, expecting some very strong growth in the industry. Along with that, looking at the population, and the baby boomer generation and the significance of them as part of the population and the fact that they typically have more disposable income and also may be more interested in some of the services to help them look younger, feel younger, etc. And so now thinking about what's happening, specifically in the industry and as it relates to transactions. First of all, I would say, we definitely consider this to be a seller's market. There has been some information lately that deal volumes are declining, financing is a bit tougher. But I think from our perspective, that commentary is really focused on much larger transactions. And, where we typically are working with clients and advising clients is generally founder-owned businesses. So we're at lower middle market. And we still feel there's a very strong interest in investing in that space. And so, we think now in particular is a great time to go to market if that's where you are in your evolution. In terms of competition, I look at this from several different vantage points. The first is more of a macroeconomic perspective in that it's estimated that about 40% of business owners today are baby boomers, who will likely want to exit their businesses in the next 5 to 15 years. And so, again, from a higher macroeconomic perspective, that means that there's just going to be a lot of businesses available for people to invest in. And so you want to be cognizant of the fact that, investors only have limited appetites or limited ability to invest, and they may become more distracted by, having more access to a wider variety and quantity of businesses to invest. Another way to think about competition is if you are in a growth phase, as we see more platforms established and developed that are looking to grow, that's obviously going to create more competition for acquisition targets that you all may be, trying to acquire. And then, I think there's the lens of looking at competition in relation to actual transaction valuations. And so, again, from a seller's perspective, having competition is really quite favorable, because typically, that's going to drive valuations, especially for, those A-plus assets. The other thing about, again, if you're in the seller seat, with increased, competition from buyers, the additional benefit for you is the fact that you have more potential partners to select from. And so, not only does that influence, valuation and deal structure, but it gives you a better opportunity to make sure that you're making the right decision from a cultural fit and operations perspective. Diving deeper into, A-plus assets and the importance of A-plus assets, I think there is, definitely a valuation gap between what we consider to be an A-plus asset and then everybody else. And so that doesn't mean that, if you're not an A-plus asset, you shouldn't go to market. It just may mean that your deal structure may be impacted, or likely have different components to it in order to make up some of the gap of the valuation that you might be expecting as a seller. I think things to consider when you're striving to position yourself as an A-plus asset. What's valued is, an experienced, capable leadership team, strong retention, both from, your providers, clinical providers, as well as other staff. Having growth, which I'll dive into a little bit deeper in a minute. As Andrew mentioned earlier, having a diverse revenue mix, and then, having strong margins. Those are all very attractive attributes that most investors are looking for. I think the other thing to be careful of, if you are growing a group, is to really be strategic about that. We've seen in other healthcare areas where people think that if they can just bring together, a certain number of offices, that will increase their valuation, overall increase their valuation multiple. And, we've really seen a shift away from that. And we've really seen that investors are more focused on the quality rather than the quantity. And so, we're not really seeing people getting, multiple arbitrage just because, they've assembled this, group of, say, 10 clinics, as opposed to bringing to market an asset that may only be five clinics, but is fully integrated. And is operating at its highest levels. And so, the last thing I'll point out is the growth. And really, growth, I think, is probably the most significant driver of valuation. And it's important to have, non-organic and organic growth. What we mean by that, organic growth is, um, in another way to describe it is same-store sales. So, if you've got, five locations, how is the growth of each of those locations individually? And you want to see that there is growth in your existing footprint. And then we talk about growth either through de novo, opening new locations, or through acquisition. And, what's important about both of those is having this pipeline. So not only a future look, but a historical look. So being able to demonstrate that you have historical growth and have been successful at either de novo or acquisition, or potentially a combination of both, and then showing a pipeline of the future. And, the pipeline for a de novo model would look something like having identified, locations that have demographics similar to where you've already been successful, and having various stages of developing those locations. So you may have some locations that you've just identified. You may have some locations where you've already negotiated with a landlord and doing your build out. You may have some locations that are going to open in the next 3 months. You may have some locations that have only been open for 2 months and haven't hit maturity. And then from an acquisition perspective, your pipeline would look something like, having identified potential targets. And again, they can be in various stages. So maybe you've got several candidates that you've just made a connection with. You have several candidates that you've had several conversations with and you think are a good fit. You've got several candidates that maybe you already have under, a letter of intent, and closing will happen, in the next, 6 months or so. And so, again, growth, I think, is something to, really focus on, and can be very instrumental in driving overall value and deal structure. So we are officially at time. I think we do have at least one question, which we'll jump to. And certainly, if people have other questions, you can certainly feel free to pop them in the chat. And let me just see.
And Maria, I responded directly to that question there.
Okay.
So we'll get William pointed in the right direction there.
Okay. So I don't see any other questions. We'll just wait another minute here. I will just say, and then I'll pass it over to my co-hosts, but thank you for attending today. Appreciate your attention. Certainly happy to dive into things further on a one-on-one basis, if that's of any interest. And I don't know, Ed or Andrew, if you have any closing comments or remarks.
Yeah, well, I think we just have Matt Gill left. Thanks, Matt, for sticking with us to the end.
Appreciate it. Thank you.
we will end our webinar here. Thanks, everyone.